outside the market. They are not be really tendering because they have been promised to on a bilateral basis within governments. I think this is something that we should look into.
Thanks very much. Elizabeth, would you like to add?
I would say in Ghana, for example, let's say the upstream petroleum sector, in order for, let's say, a foreign company to be able to acquire a petroleum agreement, they need to have a minimum of 5% indigenous Ghanaian company participation. And if a non-Ghanaian company wants to provide services within the petroleum sector, then they need to enter into a JV, a formal JV, and it has to be a new special purpose vehicle that's established with the indigenous company having a minimum of 10%. But I think what the Petroleum Commission and what the market found was that entering into joint venture agreements can be problematic, especially for the international companies when there are IP issues that they want to protect. And so what the Petroleum Commission brought forward are alternatives to joint venture companies. So for specific, normally for short-term contracts, maybe between 6 months to 1 year, the alternatives are entering into either channel partnerships or strategic alliances. So for example, for a channel partnership, all the business has to go through the local Ghanaian company. Okay, and so you will find that all invoices, all services has to go through the Ghanaian company, and so the international company doesn't even necessarily have to incorporate in the country. Whereas for a strategic alliance, each company has to split the allocation of responsibilities and role. It has to be clear. And each company has their own tax base and has their own tax obligations. And for a strategic alliance, it's project specific. So once the project has been completed, then that's it. So I think in terms of the upstream petroleum sector, Ghana has found a way to not go through formal JVs because it takes time to incorporate and go through that process. So it's particularly if it's short-term contracts, specific contracts, maybe the financing, also the capital value of the project isn't so high. Also, then you have those alternatives which the market was quite receptive to.
Thank you. Tommy, from an engineer perspective, sitting amongst lawyers, would you like to add a little bit to what you've heard?
Thank you. I think for me, based on what we've heard and looking at where, for instance, transparency and all of that sort of conflict at the end of the day, I'm drawn to, for instance, on a few examples that have happened in the country, and I think you touched on it, Karen, also in the renewable energy space, where we found, I think back then, that, for instance, local content for your solar PV panels, for instance, was designated, like the thresholds were 100%, and that sort of undermined the local capacity on the ground, and that sort of conflicted entirely with what the requirements were, and we've seen then a shift that the government now is trying to sort of open up avenues for local production, or rather reducing to react towards the challenge that was faced, or the conflict, and where now we see the thresholds are much lower, and that opens up for foreign investors to actually come into the what you call the space and be able to participate and form joint ventures, of course, and transfer skills. I think for me, that is where I see it. Thank you.
So I'd just like to chime in and give some of the practical insights coming in as a foreign contractor wanting to adhere to these local content rules, but there are some practical challenges that we see. For example, as was mentioned before, there's normally limited availability of qualified local suppliers, and sometimes the skills can also be wanting. Especially in transactions that involve cross-border investments. You've seen that, there's different applications of law across different countries, but coming in as a contractor, I have the same KPIs for the same project across different borders. So the input could be good in one country and be wanting in another. So that lack of a standard measure of what standardized local content goods, for example, would look like is a challenge. And then the other challenge is, and it's something that people don't like to talk about. Most of these local company is, as we've said, entering into very clear JV agreements with proper guidelines and good delegation authorities. Do proper due diligence before entering into these JV agreements. Know the person you're dealing with. Do compliance checks even after getting into the JV. But most importantly, do proper investment into the local labor force that you want to work with. One thing that I've proposed is, for example, foreign contractors can enter into graduate training programs with universities so that they can build capacity, from a very early level of careers. Because at the end of the day, we want to transfer these skills to the local people. At the end of the concession period, we want the project to seamlessly be transferred to the government. We talked about the train station in South Africa, for example, which is a good example of how PPPs have transitioned from the private sector to the public sector. So I think that's the essence of what local content seeks to achieve. And if we have good transfer skills and, incentivize foreign companies to actually invest in the local workforce, and it will not only have a good public perception, there's going to be goodwill in the community, but it will achieve the ultimate purpose of public and private partnerships.
Okay, so just to chime in, I think, as I said, Zimbabwe went from the one end, which was very strict and rigid regarding local content, and then we've moved to the opposite end, where it's very flexible and largely commercially negotiable. And there's positives and negatives, as my colleague has said. And when we were on the other end, we saw a decline in the industry. The industry's collapsed. Capital into Zimbabwe waned. So there were real consequences, and the very issues that local content should protect then became a negative impact on the communities in the country. Now, having moved to the other side, where, especially for the construction sector, there's freedom and flexibility in who can come in and what they can do, and whether or not it's more voluntary reporting than prescribed. We see that major contracts go to large contractors and suppliers, and also there's no real development in the local market. So that is the negative impact of that. What the government has done just in the last month is they've released the Zimbabwe Local Content Strategy for the years 2026 to 2035 to sort of balance these very technical and difficult nuances regards local content, and to give assurance to the market in terms of where they want to go. The overall idea is that they still want to maintain competitiveness and recognize the importance of bankability, but they intend to introduce a phased approach on a realistic perspective, looking at other jurisdictions on how to do it. So in Zimbabwe, we're looking at welcoming some sort of regulation, but for now it's still open. And I think how we've addressed it from a legal perspective in contracts with the government or any contract players or industry players is that we've built it into the contract, like many of my colleagues mentioned, your JVs, recognizing the importance of local content and skills transfer. We have phased clauses for skill transfer, and then shadowing as well. So I think it's a difficult topic, a timely one, but one that needs to be perfected to ensure sustainability.
Can I just add something? Again, just listening to Beatrice's perspective on how you've gone from one shift to the other. I think Ghana has, as I said, I mean, they have laws and regulations in some of the key sectors, so petroleum and mining, but there are actual legal requirements, which I think does protect the local content sector, specifically from the Ghanaians, because as part of your approval process, you need to submit certain plans. So you'll have to submit a procurement plan, an employment plan, where you intend to get your insurance, your legal services. So the law actually provides for local content in certain industries. So for example, in the petroleum sector, you can only use Ghanaian law firms, particularly those who have a principal office in Ghana. If you want to arrange insurance, you need to ensure that your insured risks are with an indigenous insurance company, unless you obtain prior approval for reinsurance offshore. In the financial services sector, you need to ensure that the company has to make sure that they bank with a Ghanaian bank. If they need to have reliance on an international institution, they need to get approval for that. It's quite similar in the mining sector as well. And I think, particularly for employment, labor, skills training, there has to be a localization plan so that throughout the period of your contract or your concession, you are working toward building up your targets. I think something that's good in Ghana is that it's a gradual process. So normally there are different targets depending on the sector and the services that are being provided, and they look at key terms. So what your percentage should be on commencement of your contract within 5 years and then 10 years. So for example, in the upstream petroleum sector, let's say for junior skilled labor, it's 100% from commencement. It should be all indigenous staff. But for management, it starts from 20%, goes to 50%, 50 to 60%, I believe, in year 5. And then they consider, by year 10, your target should be within the region of 80%. So it's a gradual target basis. And I think it does give the international companies kind of leverage and the ability to, prioritize and focus in terms of their investment and their planning. And also there are procurement lists. So where you need to procure certain services, the local Ghanaian companies can register to be part of that procurement list. And so then the international companies know where they can partner or work with or, source their goods or services from a company in Ghana that has been registered on certain lists. And so it helps with the matching exercise, and it helps actually ensuring that local content is procured properly.
This ramp-up is very relevant. I have precisely the same experience, where you ask us from the beginning the same that you will have at the end of the project. Usually it doesn't work, because it's very difficult not to have a ramp-up of local content. If you are on a project for 10 years or 20 years, it's much easier to have some expatriates on the beginning to set up, and then you will, stage by stage, ramping up on local content. I fully agree when we have the same experience.
Great. We still got a little bit of time left. Perhaps there might be some Q&A. I think there is a roving mic. If you would like to ask a question, you can just let yourself be known. If you could just tell us who you are and where you come from. So if you embarrass us, we know where to find you.
All right, we do have a question. There are some roving mics.
Sorry, Kieran, if I can also say, I know there's a number of Zimbabwean lawyers in the room. So if anyone wants to share experiences or thoughts on how we can better.
Yeah, good idea.
Yeah.
Thank you. My name is Tisile Mukoma. I come from Lesotho. It's my first time coming to this conference. I hear the panel is talking more about the local content. I'm just thinking aloud to say, is there any measuring tool or tools that are in place to see if there is any value in terms of the prescriptions or the requirements or the policies that the countries are making? Thank you.
I'm happy to start with an answer. I think there's some other people in the audience probably can contribute as well. So usually there is a reporting and monitoring requirement based on the awarding authority to actually report back on various initiatives that a project is undertaken. And it's not just saying how many projects were awarded megawatts in a particular round. It's also what was the value of the investment made from an equity perspective or from a debt perspective. What was the dilution of goods and services to in my case, South Africa, from international contractors? What was the monitoring under the economic development obligations? Were any defaults recorded as far as that go? How were they dealt with? So transparency is very important, as is auditing and monitoring, so that the awarding authority stroke government gets a very clear idea where the bottlenecks are or where the problems are. Any other panelists like to add to that?
I mean, I would say that yes, in Ghana as well, as part of the contract process, there are regular updates and reporting that's required. I think an issue, though, is capacity and capability of the regulators to actually monitor and implement the local content. I think that's, a key issue. It's amazing having, all these provisions, but actually being able to monitor and implement, is another thing. I mean, one good thing about Ghana, they have signed up to the this is for the extractive sector industries transparency initiative, and certain countries commit to disclosing certain information, including, the licenses or concessions agreements that have been allocated, the fiscal regime, the local content arrangements that have been agreed, and also trying to somehow assess the public impact that has been made in terms of the local content. I think more needs to be done in terms of research and monitoring to see whether or not local content is actually having the desired effect, and not just on the face of it. I mean, there have been some issues whereby actually increasing local content, some people or some, let's say, parts of the sectors will say, well, is that going to be, at the expense of quality? Because in terms of the capacity for local companies to, one, fund the financing to be able to participate in terms of equity, and then also just have the operational and capability and experience to actually manage the project. So there has to be a fine balance, I think, between ensuring there is local content without actually sacrificing the main objectives. I think one good thing that Ghana has done recently is we have an act called the Ghana Investment Promotion Authority Act, and that has repealed a 2013 act, which has actually made it an investor obligation to focus on prioritizing where possible, considering safety, efficiency, and economy, making preference for local providers of services and goods. And then also, they've actually criminalized fronting in that act. And also, actually, the upstream petroleum sector also criminalizes fronting. But the issue is also being able to look behind the company vehicle to ascertain when the fronting is actually taking place. I mean, there is a requirement to report beneficial ownership, but ultimately, I mean, again, it's still very hard to really ascertain whether or not the local company is actually having a say in terms of governance, in terms of financing, you know, making key decisions. So I think it's a fine balancing act. I think local content and local participation is important, but implementing and monitoring is also key for it to be successful.
Thank
If I
you.
may add, I think in adding to what South Africa actually has, Karen, from our sector, what we are doing is more on strengthening on the monitoring aspect as a regulator for the industry. Where we're using two of our vehicles in terms of our standards, which are looking at developing the industry from a local perspective. So we have one of the standards that speaks to skills development, which forces for any project that there must be an X number of skills that must be absorbed and there must be transfer thereof. So as a regulator, we're starting to monitor the implementation and the number from that perspective. And we're not just working alone as a CIDB, but we're working with other industry partners within that built environment. And together with that, another tool is the one that looks at now at enterprise development, where there are those subcontracting, JVs and so forth, that a particular percentage, being 30%, is actually, that is implemented, and we're tracking that even on projects that are for the public sector, and we're reporting that accordingly. Thank you.
Thank you. Any other questions from the audience? There's one over there.
Hi, Sean Gibbs from Hanscom. Have any of you been on projects where they've implemented a liquidated damages regime for breach of the local content requirements?
Happy to deal with that from a South African perspective. So on the South African Renewable Program, there was a regime of liquidated damages. Obviously, in English law, it's treated differently. In South African law, liquidated damages are recognized and are applied. They had liquidated damages for delays up to a percentage. And then once the project had reached COD, they implemented PLDs, performance liquidated damages. And then they combined the two to give an overall cap as such. Obviously important to ensure that in the future, because these projects are 20 or 30 years of duration, is that you have to have a mechanism that in due course, if any one of those liquidated damages were held to be unlawful or unenforceable, that you would still have the right to proceed in normal law to recover your damages as such.
In terms of local content, though, it must be quite hard proving that loss or damage. So I know people have done a liquidated damage regime.
Yeah. So in the economic development obligations on the South African programs, they didn't have liquidated damages per se. What they did is they had a points system, and the points system would then escalate. I think it was a maximum of 10 or 12, and then you could get yourself into a termination regime as such. There was a move towards a monetary consequence for failure to achieve your localization commitments as such. But I think the big stick at the end was, I think it was 12 points that could lead to termination as such.
Because it's quite different on civil law countries. Usually it's not contract driven, so you don't have liquidated damages. What you can have is an administrative offense and in certain cases even a criminal offense. It depends. But usually they do, they may be seen as as a contractual concern, but the most relevant is that usually you are not fulfilling a specific obligation that emerges from the law directly and not from the contract, and so you will have an administrative offense or a criminal offense. It's not so often that this is treated as a contractual problem.
Any other questions?
Good morning.
I think we'll take one more and then we do need to wrap.
Good morning. Tobani Mnyandu, an attorney at MNS Attorneys. Thank you very much to the panel for the insightful views. Ndombi, I've got a challenge for yourself in relation to local production and content. There's been a lull in South Africa, we should admit, ever since the 2017 regulations were struck down, and subsequently nothing has been put in place in order to assist. Section 20 of the Procurement Act, which is yet to come into effect because we are waiting for the regulations to be passed, now gives credence to local production and content. I take the point, and I've seen various practice notes that we peruse from time to time on the website of the CIDB that speak to the transfer of skills, development of people in the area where you are located with the project. There's also the issue of supplier development, but I think contractors, together with their employers, have been getting away with murder because the requirement is for us to produce in South Africa local production and content and use materials that are in South Africa. So I'm just interested in whether the CIDB has been consulted by DTI and competition at the moment in relation to what is to come in order to try and designate for our sector. Thanks.
Thank you. Not that I'm aware of, but I would like to also invite one of my colleagues who can perhaps maybe comment on that. Maybe he would have better insight on it. Richard? He's right at the back.
Thank you. My name is Richard Rapiri. I'm with the CIDB. Yeah, I think the question around local production, yes, if one looks at how, as a country we have adopted localization and also building black enterprises, it's all coming out of our past. And yes, the participants that are on the panel, there might be differences when it comes to South Africa because of our past. And therefore, there are initiatives that the government is trying to redress in terms of coming up with that. So that is why local content is so engraved, even in the highest law. And currently, like the gentleman says, is now being elevated to a Public Procurement Act, which is going to be enacted soon through its regulations. But in terms of what the CIDB is doing together with the DTIC, in terms of local content, if one looks at all inputs of construction in South Africa, they are 100% localized. So in any sort of like procurement of government, we don't allow any import of construction inputs into South Africa. But again, as a country, we have to look at that we must be competitive as a country. And yes, even if we allow international companies, which by the way are registered with the CIDB as well, we look at, as we have published as a country, the National Infrastructure Plan 2050, which then addresses are investing, and also local content and enterprise development is taken care of in those areas. Thank you.
Good. I think we've come to the very end. I'm getting dagger eyes from the front here. So it just remains for me, who chaired this session. I hope you found it informative. Obviously, there's still time to talk about this over a cup of coffee. But to my panelists, Paula, Beatrice, Ntombi, Diago, and also Elizabeth, thank you very much for participating and for sharing with us all some of your experiences.
Thank you so much. Please give them a round of applause. You know, over the past day and a bit, we've seen how valuable each of these panel discussions are, but you've undertaken the even more difficult task of getting the brains flowing the night after the gala dinner. So thank you once again. Please give them another round of applause. Panelists, please don't go anywhere. We do need a picture of you on stage. We're going to head into a very short recess. Only 10 minutes. Grab your coffee, your Red Bull, take it intravenously if you need to. Come back refreshed for the next session. And may I ask the chairs of the next 3 sessions, Sonia, Babatunde, as well as James, just to come and see me for 2 minutes, please. Thank you.
Nazalaki kokanisa ete nyonso ezali polele, kasi lelo makambo ekomi kotungisa ngai. Nayokaka yo, kasi ozali lokola mosika, ata soki tozali kaka nesika moko. Maloba na yo ekomi mokuse mingi, miso na yo ekomi obomba makambo. Nazali koluka koyeba soki nasalaki nini, pokimia na biso ezali kobunga malembe. Na yo, bolingo ezali naino, tokobungisa yango, tokoki kozonga soki tokoloba solo. Na yo, bolingo ezali naino, tokobungisa yango, tokoki kozonga soki tokoloba solo. Nalingaki te tokomona ngai ndenge wana, nazali kaka koluka kimia na motema na ngai. Makambo mingi ezali kokanga ngai na kati, nalingaka koloba mingi te, kasi nazali koyoka. Ozali koloba ete nazali mosika, kasi ngai nazali kaka na kati ya ngai moko. Biso mibale tozali kokende na nzela moko, kasi ndenge ya kokende ekomi mosika. Na yo, na ngai, bolingo ezali naino, tokobungisa yango, na ngai, tokoki kozonga soki tokoloba solo. Na yo, na ngai, bolingo ezali naino, tokobungisa yango, na ngai, tokoki kozonga soki tokoloba solo. Nalingaka te kobungisa oyo tosalaki, kasi nazali koyoka lokola ozali kokende. Biso tozalaki lokola moto moko, kasi lelo ezali lokola bato mibale. Soki nasalaki libunga, loba yango, nazali awa kaka mpo nakoyoka yo, po bolingo ya solo esengeli kimia.
Welcome to this, the 6th annual Africa Construction Law Conference.
I'm here to network. I like the energy. It's so vibrant. I'm looking forward to the sessions. They are going to add so much value to my career and to my employer back in Kenya.
It's going great so far. I've met some pretty amazing people, very smart people, and I'm looking forward to getting on stage myself tomorrow. So it's quite good.
I came to learn more about project management. I manage a practice with a pediatrician. I'm into the medical field, but I'm also looking to go over to the project management career.
I'm not aware of any African country which, within 28 days, can provide evidence that they have money to pay for a variation. So the issue is the procurement framework.
So the architecture is not a problem for the claiming parties. Where we see the disadvantages start to unravel is where the parties themselves start to abuse the dispute process.
I mean, for a contractor whose margin is being threatened, at some point it goes beyond even just margins. The contractor is thinking of survival.
Welcome to the Construction Law Conference.
I'm from James and Doris Legal Practitioners in Zambia, Africa.
From and Luke and Associates Attorneys in Gaborone, Botswana.
I'm from Mayor Brown International and I'm based in the London office.
From Bowman's in Joburg.
You're looking stunning. Can you tell me what inspired your outfit this evening?
So what inspired the outfit is the dress. I wanted something that is bridging a gap between warmth but a bit coolish.
What are you most looking forward to this evening?
This evening, I just want to appreciate the leaders, those who get awards, just want to learn from them.
Can you take us on the awards tonight? Who do you think is going to walk away with a few?
I can't tell you because I actually know who's winning. But no, they're all worthy winners. So yeah, looking forward to seeing them take their awards.
Welcome to this, the 6th annual Africa Ladies Construction and gentlemen, please return Law to your Conference. seats. Will be starting in the next 5 minutes. Please return to your seats. We'll be starting in the next 5 minutes. And panelists, please make your way.
I'm here to network. I like the energy. It's so vibrant. I'm looking forward to the sessions. They are going to add so much value to my career and to my employer back in Kenya.
It's going great so far. I've met some pretty amazing people, very smart people, and I'm looking forward to getting on stage myself tomorrow. So it's quite good.
I came to learn more about project management. I manage a practice with a pediatrician. I'm into the medical field, but I'm also looking to go over to the project management career.
I'm not aware of any African country which, within 28 days, can provide evidence that they have money to pay for a variation. So the issue is the procurement framework.
So the architecture is not a problem for the claiming parties. Where we see the disadvantages start to unravel is where the parties themselves start to abuse the dispute process.
I mean, for a contractor whose margin is being threatened, at some point it goes beyond even just margins. The contractor is thinking of survival.
Welcome to the Construction Law Conference.
I'm from James and Doris Legal Practitioners in Zambia, Africa.
and Luke and Associates attorneys in Gaborone, Botswana.
I'm from Mayor Brown International and I'm based in the London office.
From Bowman's in Joburg.
You're looking stunning. Can you tell me what inspired your outfit this evening?
So what inspired the outfit is the dress. I wanted something that is bridging a gap between warmth but a bit coolish.
What are you most looking forward to this evening?
This evening, I just want to appreciate the leaders, those who get awards. Just want to learn from them.
Can you take us on the awards tonight? Who do you think is going to walk away with a few?
I can't tell you because I actually know who's winning. But no, they're all worthy winners. So yeah, looking forward to seeing them take their awards.
Welcome to this, the 6th annual Africa Construction Law Conference.
I'm here to network. I like the energy. It's so vibrant. I'm looking forward to the sessions. They are going to add so much value to my career and to my employer back in Kenya.
It's going great so far. I've met some pretty amazing people, very smart people, and I'm looking forward to getting on stage myself tomorrow. So it's quite good.
I came to learn more about project management. I manage a practice with a pediatrician. I'm into the medical field, but I'm also looking to go over to the project management career.
I'm not aware of any African country which, within 28 days, can provide evidence that they have money to pay for a variation. So the issue is the procurement framework.
So the architecture is not a problem for the claiming parties. Where we see the disadvantages start to unravel is where the parties themselves start to abuse the dispute process.
I mean, for a contractor whose margin is being threatened, at some point it goes beyond even just margins. The contractor is thinking of survival.
Welcome to the Construction Law Conference.
I am from James and Doris Legal Practitioners in Zambia, Africa.
And Luke and Associates attorneys in Gaborone, Botswana.
I'm from Mayor Brown International and I'm based in the London office.
From Bowman's in Joburg.
You're looking stunning. Can you tell me what inspired your outfit this evening?
So what inspired the outfit is the dress.